We're live. Good morning. It is January 20th. We're in Senate Judiciary. Taking up S-193, and we have Ledge Counsel here to give us the initial walkthrough.
Okay, thank you. Kate McGlynn, Office of Legislative Counsel. Nice to see everybody. This is sharing. Oh, there we go. This is a bill about the creation of a forensic facility. There have been many iterations of forensic facility bills over the past 5 or 6 years. This particular bill is a little bit unique to the ones you've seen in the past. The past few years, you've seen a facility that would be operated by the Department of Mental Health and have more of a clinical and treatment perspective. This version of the forensic facility proposal would be operated by the Department of Corrections. And it would not be linked to the person staying at the forensic facility as being a person in need of treatment, meaning that they need the clinical definition of needing involuntary mental health care. For that reason, Eric is here. We're thinking that if you continue with this proposal in this form, that the judiciary team might be staffing it as we move forward. But for today, I'll walk you through the bill and I'll do my best to answer questions and we'll go from there. So there are 2 specific populations that this bill indicates would be candidates for the forensic facility. The first is individuals who are acquitted by reason of insanity of a crime that is punishable by a life sentence. The second group is individuals who are not competent to stand trial for a crime punishable by a life sentence. We're going to look at both of those populations and the admission criteria in separate sections. But for the purpose of understanding the bill, I actually think it's easier to jump in halfway and then go back. We have a section 4, that describes what the forensic facility is. And I think that is maybe an easier place to start. So the bill is structured numerically so that the sections appear in order. But here is our section on the forensic facility. So as the section indicates, the Department of Corrections would operate a locked, secure facility for the assessment and safe housing of persons at any stage of a proceeding falling under the Insanity as a Defense chapter in Title 13, or individuals who have been acquitted of certain crimes. This facility is what I think of as a no refusal facility. If a person is ordered to the facility has to accept them. There are no clinical or diagnostic prerequisites for coming into the facility. And forensic, clinical, and competency restoration services will be overseen by a clinical services director. And subsection B, we have a Public Records Act exemption. With this exception that any record shall be made available to the parties in the underlying criminal case upon request.
Can I interrupt and ask a question here? Perhaps I'm getting too ahead of myself, but how could there not be any clinical or diagnostic prerequisites for admission if it's required that the person is found not competent to stand trial? Because normally there has to be some sort of
that's a good question. Yeah, there would be some at the court process to determine if it's competency to stand trial. But remember, when we're making determinations about competency to stand trial, that's a different determination than if, for example, somebody is needing mental health care and would be a person in need of treatment. So I think that's what that is trying to tease out, that this assessment would be competency to stand trial in a criminal court context and not whether they need involuntary mental health treatment in the mental health context. And I'm sure that's something that we can continue to look at and tease out as we work through that. But that's sort of my quick interpretation of that.
Thank you.
Excuse me. In subsection C, it says that persons are to be admitted and maintained at the forensic facility pursuant to sections 4815A and 4819A. Those are the two sections that we haven't looked at yet that take each of those categories of persons separately for the purpose of admission to the forensic facility. And then we have language directing the commissioner of the Department of Corrections to adopt rules. I'll keep going to the end of the bill since we're here, but the section 5 is a specific rulemaking authorization for the forensic facility. So this does two things. It tells the department that they have to adopt rules, but that they may adopt, or that they shall adopt, emergency rules while the process is pending for the adoption of permanent rules. As you know, permanent rules can take about a year. And if the idea is to have a forensic facility up and running before the rules would be ready, this language would authorize the department to adopt emergency rules so that there'd be rules in place to open the forensic facility earlier. And then we have this language in section 6. And this language limits the applicability of the rules of evidence in proceedings involving competency restoration and also release from a forensic facility. So that's being added to the list here. So
where was the rules of evidence piece? I missed that.
section 6.
Ah.
There's a list and items being added to that list, proceedings concerning competency restoration, and then granting or revoking conditional release from the forensic facility. So that brings us to the second half of the bill. Now I'm going to go back up to the top of the bill. Okay. So as I said, we have two sections that are dealing with admission of two different populations. This first section deals with competency restoration services in a forensic facility. For a group of individuals who've been charged with an offense punishable by a life sentence. These are people who have been deemed that they haven't been deemed a person in need of treatment. So again, a person in need of treatment is a defined term in Title 18. A person in need of treatment is a clinical standard to be admitted involuntarily for treatment. So it's a person who has not met that standard. And it's also for an individual who is found not competent to stand trial. So that's what we're covering in subsection A and subsection B. Upon admission to the forensic facility, a person is to be evaluated for competency to stand trial at least every 6 months or upon a determination that the person is likely competent to stand trial. And the results of this are given to the court and the parties of the underlying criminal action. So there is a rolling assessment that's being done. The person is not at a forensic facility with, without any oversight. This is indicating that regularly there has to be a renewed evaluation of their competency to stand trial. So at least every 6 months, or if at some point during their treatment, perhaps the clinical director finds that they are likely competent to stand trial, they would have that evaluation done at that time, even if it's a shorter increment than the 6 month window.
Yep, and look, Senate posting.
Thank you. Is there some clinical definition somewhere or a legal definition somewhere of what it means to be competent to stand trial or likely competent to stand trial, or is that purely subjective?
No, I believe there is a standard. I'd have to look in statute. I don't have that in my fingertips. I'm sorry.
That's okay.
Eric does though. Great.
Perfect. Well, then I'll.
Obviously, competency to stand trial or turns on the defendant's mental state at the time of the trial, as opposed to the insanity defense, which is the defendant's mental state at the time the offense is committed. So competency to stand trial at that particular moment in time of the trial, if the defendant is unable to understand the nature of the criminal charges or unable to participate meaningfully in the offense.
Is there a world in which both of those things could be true, that they were unable to understand what they were doing was unable to understand the difference between right and wrong, allow them committing crime, and also incompetent.
Definitely, that happens sometimes, and sometimes it also can be one or the other, but absolutely, can be
Okay.
both. Yeah.
So we're on subsection C. If a person is, stays at a forensic facility, excuse me, the person would stay at the forensic facility until they receive a verdict in a criminal case or the charges are dismissed. So it's an ongoing stay at the forensic facility. And subsection D, while at the forensic facility, the person is to receive competency restoration services pursuant to the clinical director's plan. And that may include medication, education, accommodation, habilitation, or other services that are identified by the clinical services director. And if a person is to refuse to receive competency restoration services, that would not be tantamount to grounds for their release or dismissal from the forensic facility.
Is any of that treatment allowed to be utilized involuntarily?
Are you thinking about medications? Yes, there is a line or two about involuntary medication in the court order. Yeah.
Okay.
In subsection E, competency restoration continues until the person receives a verdict. And here we go, subsection F. The criminal division of the Superior Court where the person's underlying charges are pending must approve involuntary medication. Used as part of the competency restoration plan. The court can only approve the medication if it's clinically appropriate and likely to aid the person's competency to stand trial. So that's the standard for the involuntary medication. Okay, so that is one population of individuals that is served by the forensic facility. We're gonna take a little detour with this section 2, and then in section 3, we'll handle the second population that would be served by the forensic facility.
Okay, can I ask a question about staff here? Trying to figure out how the court would make the determination as to what medication a person should be getting. And as I'm reading it, I mean, I would imagine all the doctor or the director has to do is send in an affidavit saying this medication is necessary for treatment. Is there, would there be a hearing or would it just be sending a one-line affidavit?
The language doesn't specify. I will tell you in Title 18, the language around involuntary medication is much more robust in terms of the type of filing and the type of information that has to be submitted to the court. There is a hearing in that context. So it may be worthwhile to take a look at that and maybe cross-reference or create a similar process here.
Thanks.
Yep. Okay, so section 2, now we're dealing with a misdemeanor. If a person is found incompetent to stand trial for an alleged misdemeanor offense, charges will be dismissed with prejudice if after the finding of incompetence, the case remains inactive continuously for equal to or greater than the maximum sentence. And the dismissal is not necessary if the court finds doing so is contrary to justice.
I thought that this forensic facility would only apply to people who might be.
This is separate and sorry, I interrupted you. I knew where you're going. This is separate and outside the forensic facility context. This was part of the request, but this is specific to misdemeanors, and this is not specific at all to forensic facility. The way the draft is structured is it goes in numerical order through this chapter, and this is where this language would be added, which is sort of right in between incompetency to stand trial and insanity as a defense. So that is why it's located here. But yes, this is separate and apart from the forensic facility.
Okay.
This is specific to misdemeanors, and this is about the dismissal if the case is inactive continuously.
Okay. I guess I'm just, so they would not be eligible to go to the forensic facility. They might be found incompetent to stand trial. And then what?
Status quo, what is happening right now, the forensic facility is limited to the regulations that we're looking at, so tied to a crime, like punishable by a life sentence.
I can tell you what the status quo is. It's, what happens now is it basically becomes inactive. The person's found not competent. There are a bunch of hearings leading up to that, and then basically it's just the court saying, okay, well, we'll put it as inactive, and if something ever changes, then we'll come back to it, but otherwise it just floats off into the ether.
Great, sounds.
So this is a great step.
No, I was just trying to understand what would happen. Would that person potentially be subject to a more of non-hospitalization?
If they meet the clinical standard, potentially.
That's okay.
Yeah.
Thank you.
Okay. So that was section 2. I'm gonna move on to section 3. Again, this is the second population that would be served at the forensic facility. So A is the admission criteria. This is a person that's been acquitted by reason of insanity for an offense punishable by a life sentence. And this is a person who is not meeting the definition in Title 18 of a person in need of treatment. In subdivision B, the hearing by the criminal division of the Superior Court has to occur within 40 days of admission to a forensic facility. And in subdivision B2, at this hearing, the court will order a person committed to a forensic facility unless the person establishes by clear and convincing evidence that the person no longer suffers from mental disease and upon release would not create a substantial risk of bodily injury to another or serious property damage to the property of another. So that is the standard for holding somebody, and you'll see that language repeated throughout this section, that this is always what the court is coming back to. Does the person meet this standard of suffering from a mental disease, and upon release is the person is there a substantial risk they would cause bodily injury to another or serious property damage to the property of another. And if a person,
Is there a legal definition of serious property damage?
not in this draft, I think we have a definition of serious bodily injury,
Mhm.
but I'm not sure about property damage. I'd have to look into it. And then there's a cross reference here at the bottom of the page to subdivision D2. We'll look at that, but that is the criteria for releasing an individual from the forensic facility with certain conditions. On page 5, subdivision D3. This requires a psychiatric or psychological exam to be ordered by the court prior to the hearing, and this exam would be filed with the court. And this is this is a hearing on whether the forensic facility can continue to hold the person, whether that standard that we just talked about is met. And in subdivision 3, we have a list of exactly what the contents of the report would contain. So it would address the person's history and present symptoms, a description of the psychiatric, psychological, and medical tests that were employed and their results, the examiner's finding, and the examiner's opinions as to diagnosis, prognosis, and whether the person is suffering, again, from a mental disease or defect that upon the person's release would create a substantial risk of bodily injury to another person or serious damage to the property of another person. So that is what the exam would cover. And subsection C, we have language that placement at the forensic facility is for an indeterminate period, but that prior to release, the person must make a showing that about that standard, that they be released, they don't have mental disease, and their release wouldn't create a substantial risk of bodily injury or property damage.
Not having mental disease, does that mean they no longer have a diagnosis? Because some diagnoses you carry for life and you may be well treated and perfectly capable of existing in the world.
Mm-hmm. The term mental disease is not defined in this draft, so whether it's tied to a specific diagnosis I think that is an area for the committee to spend a little bit more time in conversation. Yeah. Okay, so subsection D, the Department of Corrections is required to petition the criminal division of the Superior Court where the acquittal was determined for the shorter of either 5 years or upon certification by the clinical services director of the forensic facility that the person meets the standard for release. So there's a regular check-in with the court. And in subdivision 2, if the court finds that the standard has been met by clear and convincing evidence, that the person is released to the community under a regimen of treatment. So that could be medical requirements, psychiatric treatment, psychological care, but that's what would be in the regimen of treatment. And in subdivision B, it says that as a condition of release, there has to be compliance with that proposed plan. In subsection E, the Department of Corrections is required to monitor the person's compliance with that treatment plan. And if the person does not follow the plan, that they would be returned to the forensic facility. And again, the Department of Corrections would give notice to the court and the court would do that same evaluation, whether the standard has been met. Does the person have a mental disease? Does the person have a substantial risk of causing a serious bodily injury or property damage? That's the whole bill.
Great, thank you. Any other questions?
Of course, yeah, Katie, so we're I'm a little confused here. This is quite lengthy, I might add, but we're an individual, finally after serving 5 years, plus like served 5 years, has found to be competent and released with conditions and so on and so forth. Will that individual then face charges that he or she were literally charged with?
This section is folks who are acquitted due to reason
Acquitted,
of
okay.
insanity. Yeah.
Fine, thank you. But there's a difference between insanity and accomplice and state trial.
Yeah. So the first section of the bill deals with folks who are not competent.
Yeah.
This section 3 of the bill is folks who are acquitted.
Okay, thank you.
Oh, it looks like Eric has something to jump in on that.
Just to add Senator Norris to help understand the distinction between competency and insanity defense, kind of goes with what Katie was saying, is that the insanity defense is a complete defense. Because that deals with the defendant's mental state at the time of the crime. That doesn't ever change over time. So if you successfully assert an insanity defense, you can never be charged with the crime again. Whereas with respect to competence, that deals with whether you're competent to stand trial. And so if you're not competent to stand trial at any moment, that can be rehabilitated, that can be restored in the future. So that if you're incompetent, you can be tried again if you're later found competent. But if you're insane at the time of the offense, you can't be tried.
Any other questions? Okay, great. Well, thank you very much. Committee, this will be one of the larger bills that we work through if we decide to undertake it. There are a couple of pieces in here that I think are important, but it will take a fair amount of time to work through all of this. And we will have plenty of witnesses to hear from as well. So just something to have on the radar. All right. It's 10:25. We have S208 up next. You take a. Do you mind if you take a 10-minute break? Let's take.